All right, so now that it's 12 o'clock, I think we'll get started. So hello, thank you all, everyone, for coming and joining us today remotely. So my name is Tim Chance. I am the Tangled Title Attorney at Maryland Volunteer Lawyer Service, and I am very excited to have you all with us today. So before we get into the substantive training, I just want to run through some quick housekeeping. So firstly, I just want to encourage everyone to please follow MVLS on social media. You can follow us on Facebook, LinkedIn, Twitter, and YouTube. We post all our trainings, upcoming trainings on social media, and we have a lot of information and events that you can stay aware of through social media. Can you go to the next slide, please? I just want to encourage anyone who is not on our pro bono panel to join the panel. And you can find cases on our pro bono portal. So if you go to the website, you'll see at the top there a link to the pro bono portal. If you click that, it'll take you to this page. Can you go to the next slide, please? So the pro bono portal looks like that. We have many different areas of law in which you can volunteer in. Just definitely encourage everyone to check that out and to see which cases they would like to take to, I guess, help Marylanders. Can you go to the next slide, please? And I just want to let everyone know about some free upcoming training and volunteer opportunities. These can be found at mvlslaw.org in the events section. So firstly, coming up on August 18th, we are hosting a remote homeowner clinic. So as part of that clinic, volunteers will have the opportunity to talk with clients to ensure that the client's name is on the deed to their home. If their name is not on the deed, the volunteer will walk with the client the steps that need to be taken to get on the deed. And if they are on the deed, the volunteer will help the client take the steps to ensure that they protect their home and their family and their legacies. And following that, we have a training on August 20th on the basics of litigating uninsured motor torts. Can you go to the next slide, please? The next one.
Sorry, it's not working.
No worries.
I don't know why it's not working.
Maybe I can, that is strange. Well, on the next slide, I just want to tell people about our recorded trainings. So this training will be recorded, just like all of the other trainings. So if you're unable to stay for the duration of this training, you can always come back to it. And if you missed a previous training, you can always access it through our website. And we have a trainings available on a variety of different areas of the law. And oh, there we go. All right, great. And so go to the next slide, please. And I just want to lastly encourage everyone, if you're, like I said, not on the volunteer panel, to sign up today. You can sign up at that link there. So for the logistics of this training, I encourage everyone, if they have any questions, to submit the questions through either the questions portion of your GoToWebinar dialog box or in the chat. I'll be monitoring both sections, and I will relay these questions to Cornelia at the end of the training to be answered. So I'm very excited to have Cornelia Bright Gordon here today with us. She's the Director of Advocacy for Administrative Law at Maryland Legal Aid. So I want to thank her so much for giving her time to present this training to us. She's a wealth of knowledge, and we are excited to hear from her today. And without any further ado, I'm going to pass it off to her.
Well, Tim, thank you for that lovely introduction. Tim asked me to do a training on the impact of inheritance and SSI and Social Security disability. And so I thought a long time about how to best present this. And so what I've characterized it as an overpayment kind of problem. So then in order for an understanding of how this works, I think that it's best to have a brief discussion about what SSI and Social Security disability are, And then you can understand how one ends up in an overpayment status by inheritance or otherwise. So good afternoon, and please feel free to draft your questions, which will be answered at the end to the best of my ability. If I don't understand, if I can't answer it, I'm going to give you my phone number and my email, and we can talk about it and I get an answer to you. So what I do is I supervise an administrative law practice. I'm responsible for statewide at Maryland Legal Aid. And the definition of administrative law is law in government. So that's pretty broad. It's the broadest area of law that we've got. It covers everything from nuclear regulatory law to motor vehicle law and public benefits, which is what I do at Legal Aid. So if, since it is so broad, sometimes we have to drill down and research individual questions, so allow that to happen. So today we're going to do an overview of SSI and SSDI and have a very generalized description of the programs so that you can understand what happens if you or your client inherits, and what you can do, what advice you can provide to try to prevent an overpayment. We're going to define overpayments and try to talk about how some ways to avoid them. Now, the basics of first SSI, it's actually called the Supplemental Security Income Program. This is part of the safety net that we have for United States citizens. It pays a benefit of a money benefit of $783 a month. And it comes with it Medicaid, full Medicaid, for aged, blind, and disabled adults or children who have limited income and resources. Most people don't realize that SSI pays out for elderly folks, and most folks don't realize that one can become an elderly person or an aged person in the United States and not have paid into the regular Social Security system. And there are a lot of people who are in that situation. And for those folks, SSI steps in lieu of retirement, Social Security retirement. So SSI is for disabled individuals and SSDI is for disabled individuals. The definition, a very general definition of disability is that you have a medically determinable physical or mental impairment, and this can be expected to persist for not less than 12 months as a continuous period, or is expected to result in your death. If you are over the age of 18, the agency will make a determination to determine whether or not the applicant has an ability to perform what's called substantial gainful activity. Because and that's working at a certain level. And if one can do that, one is not entitled to be considered to be disabled. Social Security disability is a program that's not needs-based. SSI is needs-based. Disability pays benefits to the applicant and possibly the applicant's family members under certain programs if that person is insured. And it means that the applicant has worked and paid into the Social Security fund, and there's a durational requirement. Generally, you have to work for 40 quarters. That translates usually up to about 10 years, we recommend, you tell your clients. So they have 10 years of working, and it doesn't have to be continuous years. It could be some years for a period of time, periodic, and then some years later, but they have to, the application must be within 5 years, as a general rule, of when the applicant has stopped working. So if you work for 20 years and you stop working for 10 years or 15 years, and you believe that you have become disabled, you're not of retirement age, and you apply for, or your client applies for Social Security disability, they're not going to be eligible because they're no longer insured under the program. How much money a person receives under SSDI depends on how much they earned. So who qualifies for Social Security benefits, for disability benefits? There is the agency, when I refer to the agency, I'm talking about Social Security Administration, will determine that the applicant can't do the work they did before. They can't adjust to other work because of a medical condition, that the medical condition or disability has lasted or expected to last at least a year or result in death. And the definition of disability is the same for both programs, SSI and SSDI. Now, legal aid represents exclusively low-income individuals. And so those are the clients that I see. Those may not be the clients that you see. And folks ask me, how do I tell whether someone is on SSI or SSDI, Social Security Disability or SSI? The easiest way to determine that is to ask your client how much their monthly benefit is. Because if the monthly benefit is currently $783, they're on Social SSI, Supplemental Security Income. They're not on exclusively on Social Security on SSDI. There is a possibility that a client could be receiving concurrent benefits, and we'll talk a little bit about that later and what that is. So SSI is for low-income individuals. It's means tested. In order to qualify, the applicant must have less than $2,000 in assets and a very limited income. And the income we're talking about could be from working, or the income could be from not working. SSDI is not means tested. So you have paid into the system, or your client has paid into the system, and each person who has been employed for a certain amount of time and is at least the age of 50 gets an annual report from Social Security, and that comes in the mail unless you've opted out and opted for only electronic communications. Otherwise, then you get an email from Social Security, and it'll tell you whether you have paid in and you are now qualified for SSDI. It'll also tell you what the current projected amount of your retirement would be, your monthly benefit. It'll also explain to you, should you become disabled and you have minor children, what the minor children's benefit would be based upon your work history. Now, for SSDI, the applicant may have any amount of unearned income, but if they are working, the applicant can only have a certain amount of income, or else they will be engaging in substantial gainful activity. And if they are, then they're no longer eligible, or if they're applying for benefits, they are not financially, they're not eligible. And I don't want to confuse you about financial eligibility. It is a figure that's established by Social Security annually, and there are folks, however, who have worked maybe not the whole 40 quarters, and they have a work history, and it's within 5 years of their application, but they haven't worked the full amount to qualify for SSDI. Those people are not shut out. They may be eligible for what's called a concurrent claim. They get paid out of the pools of money for both benefits, and they're separate pools. So they get paid out of the SSI funds, and they get paid out of the SSDI funds, but their total benefit amount is not going to exceed the SSI benefit amount. So it's going to be currently for this year $783. How do you figure that out? Well, first of all, every client gets an award notice every year that explains what benefits they receive. Also, SSDI recipients receive a 1099 at the end of the year. Clients might not know, but they usually know. And if it's necessary for you to figure it out, then you can ask the client how long they worked. And my rule of thumb is I ask the client to look back over their entire work history and tell me how many years did they work if you added it all up at once. Because many of our low-income clients who are disabled have been prevented from working straight like you or I, and they may have a work history that persists over a period of time, and I call it a periodic work history. So Social Security can impose a in-kind support and maintenance on our clients, and what that means is Social Security can decide that they're going to pay a recipient less than the statutorily noted amount. So your SSI, and this is for SSI, your SSI client may receive less than $783, and they're coming in saying, I don't know why, but I'm only getting $590 or $600 and some dollars. And it may be that Social Security has determined that someone else is providing food, shelter, etc. for the client, and there's a formula, and Social Security can reduce their benefit. So we talked a little about substantial gainful activity. Eligibility for disability benefits requires that the client is unable to engage in SGA. The amount of monthly earnings considered to be SGA depends on the nature of a person's disability. The Social Security Act provides a higher SGA amount for folks who are statutorily blind than for non-blind individuals. We are in this training, we're going to focus on non-blind individuals, but I just wanted to share with you that the SGA for statutorily blind folks right now in 2020 is $2,110. For non-blind individuals, the monthly SGA amount in 2020 is $1,260. That's a big difference. And the folks there are various other differences in the way the Social Security Act treats non-blind versus blind individuals. So we know that as a policy matter in Maryland and in the nation generally, we want people to be able to work. The SSDI and SSI are not the default options. We want folks to be able to work. So to that end, the Social Security Administration allows a recipient, they have to have been determined eligible, a recipient a trial work period of 9 months to see they want to go back to work and try to work. It's a fairly complex determination when there's an overpayment and there is a trial work period. And if you think that you've got a case like that, I encourage you to consult with Maryland Legal Aid because our staff are pretty adept at figuring that out. It takes a fair amount of work and pulling up the entire Social Security file. So what if a person who has been deemed eligible either for SSI or for Social Security disability, and the agency has determined they've engaged in substantial gainful activity, means they've been working for over the SGA amount for a period of time. Well, they're going to get a notice that they have been overpaid. If you would like to consult with us about overpayment cases, we'll be happy to do so. We do know that Social Security makes mistakes when calculating overpayments for SGA. And so we go back and we look at the work history year by year, month by month, in some cases, over a period of years to determine whether or not the allegation of overpayment is correct. So we've talked about, well, how are you eligible for these programs? Or you think that you have a client who has become eligible for the programs, how does one apply? For right now, during this pandemic period, it's a little different. For SSDI, you can apply online, your client can apply online, you can, client can use a social worker to help them, they frequently use family members to help them. It's a very directed process and abundantly clear if it's done online. The Social Security website has a lot of clarity in the application process, and there's an initial application done, and then documents are provided. You have to get the documents, their medical releases, etc., sent back in, and then it's the Social Security Administration will direct them from there. A person can apply by telephone, and a person can apply in person. And the vast majority of low-income people apply in person. They go into Social Security, and someone helps them with the application process. Now, we know that the Social Security offices have been closed since sometime in March of 2020, maybe April, and I think it's March. And so no one is going into the offices to do an application now. Social Security has made a number of exceptions available, including online access. So your client, you thought the client was eligible, the client has applied, has successfully applied, This whole process takes months usually, and the client is in pay status. Yay, finally. So they're getting, if the client's on SSI, the client is getting his or her smaller monthly benefit, but this client has access to a full panoply of the traditional Medicaid program. And I distinguish traditional Medicaid versus ACA or Affordable Care Act Medicaid. So this client has access to probably the biggest health insurance program that exists in the United States, which is quite meaningful. But you think things are going along really well, and then your client calls you up and says, I got this letter in the mail that says I've been overpaid. So you tell the client, rush on into my office with that letter so I can see it, or photocopy and mail it to me. And you know, as a adept attorney, that the overpayment that's been alleged by the agency is the difference between the amount received by your client and the actual benefit amount the agency believes that your client is due. This is a retroactive determination by the agency. It's a look back at what your clients got and what they think your client should have got. What causes an overpayment? Well, income. Clients work. They start working, or they've been working. They start working more than they used to. Living on a $783 a month is tough, or $1,200 a month is pretty tough. Or the client can have a change in their living situation. A client starts to live with their sister or their mother, and the agency starts thinking that perhaps that client has in-kind distributions from that mother or that sister, or the agency has deemed part of that mother's income to the client. And that can cause an overpayment, because then the agency believes that the benefit to which they're entitled has been reduced, and blammo, the client is in trouble. It can happen with a change in marital status. A lot of folks don't realize that if you get married, it's not just the pastor or the clerk or the judge that knows. There's a report that gets filed with the Social Security Administration immediately. And so during my practice has persisted over a period of time before computers, and now where the agencies can speak to each other quite adeptly. And we have seen the marital reduction in benefit eligibility happen really fast, much faster than we used to see, within a month. An overpayment can happen if the client is no longer disabled. Folks get better. The disability rules relating to folks who are asthmatic have changed dramatically, and medical improvement has existed for asthma and for certain other types of benefits where people can increase their quality of life and improve their medical condition quite drastically. So the agency does no longer consider them disabled. But they continue to get benefits. That can be an overpayment. If a client dies and still receives benefits in their name, and the benefits are accessed, that can cause an overpayment. And well, you might say, well, how are they going to get that money? Are they getting it from the estate? Frequently, clients have something called a representative payee, and the agency is trying to get that money from that, what we call rep payee, the person who's been helping the client. Most recently, I had a case with a rep payee where there was a mother-daughter situation, and the mother died, and the agency is now going after the daughter for 1 month of benefits. An overpayment can be caused by a failure to report a change to the Social Security Administration. Usually it's a change of income, living situations, that kind of thing. And for most public benefits that I see, it's usually 10 days. People have to report a material change within 10 days. And believe it or not, the rules in all public benefits that I know of require folks to make these admissions against interest. And they could get charged with fraud, not only the overpayment, but fraud for failure to do it. Okay, so what happens if Social Security is alleging that your client has been overpaid? The agency will send a notice asking for a full refund within 30 days. Ha ha, right, they get a bill for $50,000, $60,000, $70,000. Haha, not funny. Most people can't do that. If the person does not make a full refund, the notice will advise them quite precisely that the overpayment will be recouped from their monthly benefit. In the case of a person receiving Social Security disability benefits, the agency can take the whole monthly benefit. So your client can be moving along, has managed to organize their life to be able to live on this modest income and with great difficulty, and then all of a sudden get nothing the next month. For a recipient of SSI, the law provides that the agency can only recoup a maximum of 10% of the full monthly amount. So that means that your client's coming to you and saying, my check was cut, it's set, and you'll say, well, how much is it reduced? And they'll say, I don't know. And you look at it, it's $78. You know that your client has been recouped for probably an overpayment. Now you might ask, well, why doesn't the client know? Low-income folks have a lot of stressors in their lives, and they experience upheaval that most people don't. Well, I'll say many people don't get exposed to this regular upheaval that low-income people do. Right now, during the pandemic, it's much easier for people to understand and visualize this. My clients get evicted. They move a lot. When you are evicted and the turmoil, and your whole family is evicted, the turmoil associated with that may cause you to forget to notify Social Security of your new address. This is only limited by your imagination and what happens to folks who are low income. A lot of them end up in shelters. Some of them end up on the street. The notice will tell the client the month the proposed withholding will start, will explain the appeal rights, the appeals process, which is completely two different things, and how to ask for a waiver of an overpayment. I want you to know that if a person applies for a waiver and it's denied, there's an appeal process for that as well. That's not in the notice though. Should you have questions about, and we have time, I certainly can go into the appeals process. So what are your clients' options when they're notified of an overpayment? And is it different for the recipient of SSI versus SSDI? Okay, because remember, we've got in the back of our mind that we're talking about inheritance here and what would happen if a person on a needs-based program receives an inheritance. Well, the client may deny the existence of the overpayment, and that would mean that the client would appeal. The client could believe that, yeah, I was probably overpaid, but I sure can't afford to pay back this $60,000 they're asking for me. So they might ask for a waiver of the overpayment. You and the client may try to negotiate a lower repayment amount for the similar reasons, or the client, as we frequently see, doesn't even get the notice, does nothing. Well, what happens? And what happens is what we talked about, and we'll talk about, is recoupment. Make sure I've got the right one up. So filing an appeal. The client can file an appeal and a waiver. Many times, lawyers advise clients to file the appeal first because a waiver can be done at any time, but an appeal must be done. The appeal period is 60 days from the date of the letter. The agency, and this is the only agency that I know of that does this, provides for a 5-day appeal period, 5-day mailing period. So the appeal ends up being frequently referred to as 65 days. Should your client, like my clients, fail to comply with the appeal period, but they have a good reason, they were in the hospital, they were incarcerated, or there's, in your opinion, as a good attorney, good cause for failing to comply with that period, what you do is you advise the client to go ahead and file the appeal, and the appeal will percolate along just like a client who's filed within the 60-day period. And you can also put on the appeal document that the client had good cause and what the good cause is. And should this matter end up being denied for timeliness, there is an appeal and there process that would take you all the way up to an ALJ, and you can litigate the good cause allegation. And should you be successful, the ALJ will hear both things at once. First, the good cause will make a decision on the good cause determination, and if good cause is found, then make a decision on the merits of the actual application for benefits. A waiver is different. A waiver is where the client's not disputing the correctness. It's asking the agency to forgive the overpayment. There's no deadline. The client can file that at any time. Frequently, the client is coming in your office or where they've suffered a recoupment, and if there is a waiver filed, the agency is supposed to stop recoupment pending the review of the application. I put allegedly because many times it does not happen, and my staff have had to, or I have had to advocate with the agency to get that recoupment to stop. The reason why we exist is that folks make mistakes. You know, it's the rare person that wakes up in the morning and looks up at the sky and says, "It's a beautiful day. I think I want to go see a lawyer." No, because people come to see us with problems. And so Social Security, I told you, is only supposed to recoup 10% if they're on SSI. I've seen Social Security make a mistake and recoup an entire benefit amount. So that's why I said allegedly. And also right now, it's really bad for people because folks who, and I have a client like this right now, folks who filed a waiver in, say, early March, while the agency was considering it, the agency stopped working on appeals or applications for waiver because they're not in the offices. The district offices aren't open. Some have started reopening. I just want to say that. So you have to call your own district office to find out. Nevertheless, the recoupment has persisted during the entire pandemic period. So even if my client would have been eligible for a waiver, his income has been substantially reduced for March and for April, for May, for June, and now July. That's 5 months, and it's a lot of money to somebody who's only getting $783 a month. Waiver requirements. This isn't if there's an overpayment, the recipient must be without fault, and the statutory requirement is that the overpayment would defeat the purpose of the Social Security Act by causing financial hardship, or would go against what the agency calls equity and good conscience. And that's a good lawyer can drive a Mack truck through that. That's very broad language and a source of considerable advocacy. Without fault means that your client is blameless, and it's a fact-based determination. The client might have a representative payee who failed to report a change in income. You know, your client may have been determined by the agency that they can't manage their own funds. That person could have an intellectual disability, cognitive problems, might have other medical problems that interfere with their ability to manage their own funds, and they have a rep payee. That person can really mess up a client by failing to do what they're supposed to do. So client could have failed to report changes. Client could have become institutionalized. That happens a lot. People end up in nursing homes. They end up in the hospital. They end up in jail. Or the client could have received an inheritance or other financial settlement. And that is, here we are, an overpayment surprise. So this is what I call the recoupment golden rule, the governmental recoupment rule. What the government giveth, the government can taketh away. This provides a little bit more detail, and also I want you to know that the minimum monthly recoupment amount is $10, and we are frequently able, and we have a form that we use, and we make that available to you if you need it. We can negotiate a reduction of the recoupment rate all the way down to $10. And that your client might find to be much more acceptable than going through an appeal, you know, a waiver and then appeals related thereto. So here's what the crux of this discussion. We don't want our clients. Now we know what an overpayment is, but we don't want our clients to have an overpayment. So from a perspective of inheritance, how do you avoid an overpayment? Now that we're situated and we've defined our terms, so we're going to make some assumptions for the rest of this discussion, and that there are some funds available. What I usually see is a disabled adult child. That means that a parent has a child or had a child that became disabled during childhood or at least before the age of 26, and the parent would, or relatives or good-natured people in a congregation, etc., would like to establish a safety net. Wants that disabled individual to maintain their benefit status, but does not necessarily want that person to impoverish themselves, or in lieu of that, to have funds that could be available. So it didn't used to be like that. And you had to be, for SSI, you had to be impoverished to be financially eligible. And this was problematic, especially for middle income people who were parents who started aging. I'm getting you to start thinking about estate planning for your clients and what's going to happen to this child after I go. Or we don't have much, but by the time that you talk about add up our assets and our child inherits them, they're no longer going to be eligible for SSI, and well, that means they're going to lose their Medicaid. And well, before the Affordable Care Act, that means they lose all their health insurance with no possibility of getting any more unless they can qualify under a standalone application for traditional Medicaid. Congress created the ABLE statute, Achieving a Better Life Experience, in 2014, which permits states to enact legislation permitting individuals with disability to create tax advantage accounts for folks who are disabled before the age of 26 to save money for certain purposes without affecting this recipient's eligibility for means-tested public benefits. Okay, so what are we talking about? We're talking about SSI and folks on traditional Medicaid. It's a safety net. There's a lot of movement to reduce, and the safety net has been reduced in the last few years significantly, and there's a lot of movement to eliminate certain provisions of the safety net. As an attorney who's been practicing for a while now, I've been practicing for 40 years, I've yet to see well, it's a rare thing to see an individual who has sufficient depth to their pockets that they or their immediate family don't need to benefit from the safety net. So it is my belief that we're marching in the wrong direction here. Okay, so we're going to talk about the safety net for disabled adult children, and how else for people who inherit or expected to inherit, individuals who want to shelter expenses for their disabled adult children, or also we have folks who have received some personal injury settlements and inheritances that we need to look carefully at how these funds could be sheltered to protect this disabled person and enable them to continue to use the safety net. Key features of an ABLE account. The ABLE account, and you see I'm leading with that, it's my favorite. ABLE accounts let people who were disabled before the age of 26 save their own funds or receive money from others to pay for expenses to become more independent. Money in an ABLE account does not affect their eligibility for federally funded means-tested public benefits programs. The money in the account is not taxable generally, and Medicaid can't claw it back. I have tried to make sure that you all have citations of authority and resources. There's a good website called the marylandable.org. I commend it to you. So an ABLE account, one account per beneficiary. So if you've got a family with multiple disabled children, each child can have their own ABLE account. It can be established by the beneficiary, him or herself, a parent, a grandparent, guardian. Anybody can contribute money to the account. So if you've got a GoFundMe going on, that can go into the ABLE account. Each contributor can deduct up to $2,500 a year for single filers on their state tax return. The maximum annual contribution received per account is $15,000, but the minimum deposit to open an account is only $25. This is a flexible statute. It is what I call good news. It can be opened at most banking institutions. It does not require anything special, a lawyer. It does not require a trustee. It doesn't, there's not a whole lot of complex legal loopholes for folks to jump through. All you have to do is walk into a bank and say, I want to open an ABLE account. The maximum lifetime account balance in the account is $500,000. I have a link to some FAQs that you might find helpful. The beneficiary can control distributions from the account. Now, when you look this up, you'll see terms like a competent beneficiary can control distributions from the account. I didn't put that in because folks mix up competency versus capacity. There's a whole training that I'm going to do, hopefully in the fall, on competency versus capacity, and I commend you to it. Tim will probably know because I'm going to include him in my circle of emails when I send out trainings. The withdrawals from an ABLE account has to be used for what the statute calls a qualified disability expense. But the list of possible choices is so broad, it is what you would call a super safety net provision, and it's a good thing. For SSI, a beneficiary of SSI can have $100,000 saved in an ABLE account, and it does not count towards the $2,000 asset limit. It's a lot. Where do I see this? I see it frequently where a child becomes disabled during childhood or adolescence. There's certain mental illnesses that exhibit frequently during adolescence and young adulthood. That would be schizophrenia and bipolar disorder. And this child becomes an adult and is a legal stranger to their parents' income and assets, and can become eligible for SSI on their own account, and frequently do. And the parents are aging and recognize that when they die, that kid's in trouble. They call it a kid. You might not consider it a kid, but they've opened an ABLE account and they have started putting funds in there so that that person is protected. That's a hypothetical that I want you to consider when you're doing estate planning for folks who are disabled or who have disabled relatives. Should the ABLE account go over 100,000, then the SSI is suspended but not terminated until it's spent down back to 100,000. And what you have to tell your clients is that they'd have to bring a bank account into the district office and prove that the account has been spent down. To open an ABLE account, a person must meet Social Security's definition of disability, and they have to have proof. So it's not like the kind of proof you have to prove for Social Security. You have to prove it to the bank, okay? And so the bank might require you to bring a letter from your physician, a letter from the client's award letter, etc. So security can get in it and say, oh, we don't believe this is true, if that proof existed at the time the account was open. So this page generally talks about what the ABLE expenses can cover, which we've kind of gone over. It's pretty broad. I've given you some resources. I and the inimitable, wonderful law clerk, Rose Richardson, who helped with this presentation. I have to give Rose a lot of credit here. There are some other planning tools that you can use to advise your clients. Now, a special, everyone, I don't know the background of everyone here, and I hope I'm not talking down to you guys. We all know what trusts are. What I see is when the trusts are done wrong. And a well-meaning attorney gets a person who's on public benefits and they create a trust account or a trust document that does not meet the statutory requirements. I am not a trust attorney and I don't do trusts, so this is going to be pretty broad. A special needs trust is something that's recognized by the Medicaid program and by Social Security, so that people with financial resources can, the resources can remain available to them, and the individual can also continue to be eligible under the program. By statute, these trusts are protected from immediate invasion by the state Medicaid agency. And the beneficiary, if you're going to create a special needs trust for your client, beneficiary must be under the age of 65. So this audience is aware that a trust is a legal vehicle where one party is holding property for the benefit of another. In certain situations, a trust can be set up for an SSI recipient, where you're going to see is somebody will come in and they've got a payout, a lead paint judgment, slip and fall, any other kind of judgment. You want to keep your client eligible. A payout from a regular trust can and does negatively impact the resource-based public benefits programs, all of them. Medicaid, SSI, food stamps, anything where there's a income and asset limit, that's where these folks are going to run into trouble. Where it really causes problem is if you have someone, take my hypothetical, where the person has significant mental illness, the adult child. That person really needs access to their medical assistance because that person might be under the care of a psychiatrist, might be receiving psychotropic medication, may be subject to frequent psychiatric hospitalizations. They need their Medicaid. So if a trust is inartfully created because it's not taking into account the laws relating to the disability programs, then this well-meaning lawyer can and does create a lot of problems.
Okay.
So
Oh, sorry. I just want to just jump in to say that we're brushing up against 1 o'clock.
Okay. Exception. So do you want me to stop at 1 precisely? People can drop off if they need to.
Okay, yeah, you can say, I think we're coming towards the end, so yeah, you can continue.
It's not much, there's not much more.
Okay, yeah, that's fine.
Okay, the exceptions are special needs trust, pool trusts, and undue hardship exceptions. This is a complex area and it needs specialized treatment. I have given you some information which you can read on your own about special needs trusts. I just want you to know that it is a statutory creature, and the Maryland Attorney General's office has a checklist and actually reviews the trust documents before they are submitted to clients. The better creature than a special needs trust, which can really have a lot of problems associated with it, are pooled trusts. And this is a type of special needs trust. There used to be only 2 in Maryland. Well, first there were 1, now there's about 6. And you can read yourself how they're funded. The difference between that is that the disabled person's income goes into a pool with other disabled individuals. And also, upon their death, Medicaid will receive a payout of any money that has been spent for that disabled person on the Medicaid program, and that the money that's in the trust remains in the trust. It does not become part of the estate. I've given you the list of pooled trusts in Maryland. The most common in Baltimore area is the First Maryland Disability Trust, which was created by members of the Elder Bar. Remember that as a general rule, trusts, if you want them to, as an inheritance protection, they must be irrevocable, and consult a trust attorney. So the types of inheritance that we see is outright cash, stocks and bonds, an IRA, proceeds from an IRA, real property, and personal property. So what I've tried to do is to give you enough information of what direction you can go to protect the client before there's an overpayment. And in the event that it hasn't been done as a matter of estate planning, what you can do for if a client's inherited funds, how you can construct the vehicle that might permit the client to remain eligible for benefits, at least in the period of time subsequent to you creating the ABLE account or the special needs trust or the pooled trust. So it's been my pleasure to talk to you. I've covered a lot of ground. If you're able to stay, if you have any questions, I'll be glad to answer them if I can.
All right, thank you. Thank you. We actually do have a few questions. So the first one is, so would a life insurance policy payment be considered an inheritance?
It can be, and it frequently does. I see those a lot where people can get them and they are thrown off of their benefit program. So the recipient receives life insurance as cash, the payout, and it's considered a income the first month it's received, and after that it's a resource, and it will throw a client off of SSI quite rapidly. The trick to do is to make sure that the client spends that down, consult with an attorney who understands the overpayment rules, because not all of the money is countable towards the client's resources. So $1 doesn't equal $1 necessarily in Social Security land. Okay? There's some exceptions to the counting of the income. Next question.
Okay, thank you. So are there amounts and or types of inherited assets that don't affect the receipt of benefits?
Personal property generally doesn't affect it unless you're talking about receiving some gold and jewels and pearls and sterling silver, that kind of thing. As a general rule, personal property isn't counted. If a client receives an inheritance of personal property and Social Security starts making an allegation of an overpayment, we'd be happy to consult with you. Real property is problematic because many of our clients, at least in the Baltimore area, own their own homes. Your A house is excluded from calculation of financial eligibility under most programs, and I'm talking food stamps, Medicaid, Social Security. Nevertheless, some of our clients inherit additional property items, and that is problematic. And we'd be happy to help you work through that.
Right, thank you. And I guess the final question is, unless we have any additional questions. So we talked about SSI and SSDI today. I guess could you briefly cover the impact on like SNAP, medical assistance, or Section 8 housing that an inheritance might
Well, I'm not a housing attorney, but we do have housing experts at Legal Aid, and I'd be happy to connect that person that has the Section 8 question to a housing attorney. But the general rule is that for means-based programs, and that's Section 8, that is certainly food stamps and traditional Medicaid, as well as Affordable Care Act Medicaid. And I want to distinguish between there's big differences there. The inheritance can certainly, and receipt of money can certainly make one become ineligible for the programs, unless there's someone that can help the client, or the client is savvy enough to construct one of the vehicles that I've talked about earlier. It happens all the time.
Right. All right, thank you. Let me see, what's this? We have one last question. Okay, so it looks like someone raised their hand. That might have been by mistake, though. I don't see any further questions. So I just want to thank everyone for attending. I want to thank you, Cornelia, for presenting. This has been extremely informative and extremely helpful. And I believe that concludes the webinar. So take care, everyone.
I will say that, Tim, you can send the PowerPoint at will, and my number is 410-951-7728. Call me at will.
All right, thank you. So the PowerPoint has been uploaded to the handout section, so you can access it there. But if anyone has any issues getting the PowerPoint from the handout section, just reach out to me and I can send it to you directly.